Hello,
Hello.
can you hear me?
Everybody,
Yes.
Okay, I think I've got criminal docket here. Commonwealth of Kentucky versus John Anderson, is that correct, Mr. Stockton?
Yeah, he's first on the docket, Your Honor.
Okay. I note that there's a document. If you are involved in this case, leave your camera on. If you're not involved in this case, flip your camera off. Okay, thank you. Commonwealth of Kentucky versus John Anderson, 19 CR 0010.
Judge, he's got an active warrant on him, and his girlfriend has called today, but he's not been picked up yet.
Okay,
Don't have to worry about that.
okay, we'll pass over that case. What did the girlfriend call about?
She wanted to know how she could get on the Zoom link. I didn't talk to her myself. They just texted me and told me that she called this morning.
I guess they want to monitor what's going on without coming, it sounds like to me, so, but that's okay.
Just concerned citizen.
Yeah, if you're out there watching, we'll see you when you get here. So. Savannah Branham.
Morning.
Hello.
Hello.
Commonwealth versus Savannah Branham. We're here today for the purpose of arraignment. Are you Savannah Branham?
Yes, sir.
And what's your year of birth?
1993.
And what's the last four digits of your social security number?
6915.
Okay. You're here today for the purpose of arraignment. You're represented by the Office of Public Advocacy, Ms. Costello. Do you see Ms. Costello there? You have the right to remain silent, Ms. Branham. I suggest that you do take advantage of that right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with burglary in the second degree. Do you understand that charge?
Yes, sir.
Okay. Is there, Counselor, do you acknowledge the identity of Ms. Branham, the receipt of the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor, and this is actually one that we had an agreement on, maybe paperwork in the file.
Do what?
We did an information instead of an indictment on this case, Your Honor, and Mr. Stockton had made an offer there. I believe there's plea paperwork in the file that Ms. Branham signed.
Well, that's on the other case then, right? Is there another case?
This would wrap all of our cases up, Your Honor.
There is another case though.
Yeah, there are a series of cases.
Okay, and I don't have that on the docket. It's the problem.
Oh,
So I don't have it here in front of me. Is there any reason why we couldn't do that next rule day now that she's been served with this?
I have no problem. She's in specialty court and doing well as far as I know.
Okay, well, let's schedule this for April the 22nd, okay? You'll be back available April 22nd. Be in contact with your attorney before then, okay? Next case is Joshua Brooks.
Read that.
Good morning, sir.
Hello. This is Commonwealth versus Joshua Brooks, 11 CR 0043. Are you Joshua Brooks?
Yes, sir.
What's your year of birth, Mr. Brooks?
88.
Okay. Now, if you're involved in this case, have your camera on. If you're not involved in this case, have your camera off, okay? Okay. This is a motion to revoke. Attorney, who are the attorneys in this case?
I think Mr. Brooks had public defender back years ago when he pled on this case. I don't know if he's eligible now or not. This is the issue, Your Honor. I don't know if we want to go into it or if you want to make sure he has counsel first.
Well, just state the issue before.
The issue is Mr. Brooks.
Let me ask him one question. Mr.
Okay.
Brooks, do you have a job or do you have any money?
Yes, sir.
Do you want to
I'm
have,
full-
well, wait just a second. Do you want to have private counsel? You want to have a lawyer?
No,
Well, you need a lawyer. Who you looking at there, Miss?
my wife.
Okay. Well, is she your advisor on this thing? Man, she doesn't think,
No, sir, she ain't.
well, that usually the way it is, so that's okay. That's okay. Tell me what's going on, Mr. Stockton. So,
Your Honor, this is an 11 case, and Mr. Brooks and Christina Brooks were involved on a criminal mischief case, theft case, where the substantial amount of restitution, I think, is around $20,000. They both entered pleas where they were jointly and severally liable for the restitution.
yeah.
Mr. Brooks's co-defendant is currently in prison, Miss Christina Brooks. Mr. Brooks is out and he's paid over half the restitution. And I don't know if he's refusing to pay or doesn't want to pay, but he's got to understand that he's liable for all of it. Even though he may have to pay over half of it since he's co-defendants in prison. So I just want him to keep paying restitution. If he'd rather go to prison than pay restitution, I'll try to accommodate him. But that's my position.
Okay, well, I think he needs to have a counsel to advise him on his rights on this thing. Mr. Brooks, you need to get you a lawyer. If you can't afford a lawyer, file an affidavit with the court, call the clerk's office and file an affidavit. Your case will be rescheduled for April the 22nd. And I don't know, we might be back in person by then, so you'll.
Hey,
Is there
Jesse,
any way I can just pay this off and be done?
Yes, there is. How much is left on it, Mr. Stockton?
I think there's about 5,000 left.
Now, from my understanding, I've heard that she's no longer in prison, that she's out and she's living somewhere up towards Campbellsville. And
Well, if
she's been paying me for a couple months.
if she's out and she's paying some on parole, that's good. But I think it's the Commonwealth's position, you still need to be making payments until it's paid off. If you'd rather do that instead of paying it off.
How much were the payments that were required?
See.
I think it was $105.
Yeah,
month.
I think that's right.
Yeah. Well,
Miss Brooks is out of jail and she's been making $50 payments each month.
Probably what the parole board said.
yeah. Well, do you have any objection to him resuming the $104 month payments, Mr. Stockton?
No.
You just resume the $104 month payments, Mr. If that's all right with you, okay? Okay,
That's
thank
fine,
you.
sir.
Thank you for being here today. Okay.
Thank you.
Brandon Gadberry. Commonwealth versus Brandon Gadberry. Are you Brandon Gadberry?
Yes,
Were you born in 1980?
yes,
Last four digits of your social security number, 5344?
yeah.
Okay. We're here today. You're represented by, who represents us, Ms. Costello? You're here today on a motion to revoke, is that correct?
Yeah,
Mr. Stockton, what do you have in this case?
Your Honor, this is the second motion to revoke on Mr. Gadberry. He's got a 3-year sentence on possession of controlled substance, first degree. And I guess I'd want Mr. Cooper to pick up around spring of last year when he put Mr. Gadberry in rehab.
You're referring to
When he was taken to West Care.
April or March or April?
Yes.
Okay, Mr. Cooper, you raise your right hand.
Yes.
Where the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
Okay, lower your hand, identify yourself, with whom you're employed in what position.
My name is Gregory Cooper. I'm employed as a probation and parole officer with the Department of Corrections Division of Probation and Parole.
Okay, go ahead.
Now, Mr. Cooper, in the spring of last year, did Mr. Gadberry have some sanctions where he was ultimately referred to a rehab, long-term treatment?
Yes, he had some violations regarding substance abuse where he had a issue with alcohol. It had been a bit of a problem during the course of his supervision. So we referred him to the social services clinician that ultimately referred him to West Care, which is a rehab here in Kentucky. And
Where's it located, if you remember?
I want
Harlan County?
yeah, it's all the way in Harlan County. And probation and parole actually privately transported him all the way to that rehab. Is Judge Williams still in this call?
He is. He just muted. Go ahead.
Oh, okay. All right. Anyway, we actually privately transported him all the way to the rehab, and he was told that he needed to stay and complete that rehab. This was March 6th was whenever we transported him to West.
Did he complete that rehab?
He did not. April 12th, 2020, he actually left the treatment facility and ultimately absconded. So he failed to complete this treatment for substance abuse, and we didn't know where he was at.
Okay. And at that point in time, I believe the Commonwealth filed a motion to revoke, and he was given a 30-day sanction. Is that correct?
Yes. After you all had a hearing back in May 20th, 2020, he was ordered to restart his probation, and he was supposed to have a strict curfew, and he was only allowed to be at home, work, church, and doctor. And I don't have it documented in front of me, but I believe he was supposed to go live with somebody in Adair County.
Okay. Did he comply with those restrictions?
He did not, because he actually got arrested. It appears that I did not put the time of the arrests in these, so I'll leave that out as a violation. But obviously he wasn't staying at home because he was out in the public drinking or drunk in public. Let's see.
Well, I'm showing he had a public intoxication arrest in Russell County on 12/10/20. Is that what you're referring to?
Yes, where he was in his driveway, and it was because he was causing a disturbance at the residence.
Okay. And I'm also showing he has a public intoxication arrest on 12/27/20. Is that correct?
Yeah, not even a month later. I mean, it was 17 days later. He was arrested at his house, trying to get into another residence. Trying to get into another residence. And whenever the police officer had arrived, he saw that Mr. Gadberry was manifestly under the influence. And he even noted that Mr. Gadberry had been charged with this 2 times previously within the last year, in February and just a couple of weeks prior.
Now, was Mr. Gadberry undergoing any treatment or counseling during this time?
Yes, we had referred him to the clinician again after his 30-day sanction, or during his second chance at probation. He was referred to the clinician, and he was supposed to complete IOP through, I forget the name of this acronym, but it was RRJ. It's in Russell County. It's similar to Adonta's IOP program. It was just more local to him. So we tried every way that we could to accommodate his transportation issues. And he ultimately wasn't complying with that program.
Was he terminated from that program?
I'm trying to find that date for you.
Look on January the 3rd of 21.
Yep. Yeah. Well,
You received notice that he was terminated on 12/21/20. Is that correct?
Yes.
Okay. Now, did Mr. Gadberry report as he was supposed to in January of 21?
No. Whenever he was released from Russell County Detention Center, he did not report his recent arrest within the 72 hours that he is required by our conditions of supervision.
Okay. Did he have a regularly scheduled report date in January?
Yeah, I have always told Mr. Gadberry he is to report by the, or report on the second Wednesday of every month. And in January, which is namely January the 13th, which would have been the second Wednesday, he failed to report that day.
What actions were you going to take as a result of that failure to report?
I was going to investigate his home place to see if he was residing at his residence, and I was going to ultimately investigate to see if he had absconded from us because I had lost all contact with him. In spite of me trying to make numerous attempts to contact him by phone, I was going to exhaust the final measure by going to his house. Due to COVID, we have a lot of restrictions on how often we can do home visits, and I was unable to do so. However, on January 29th, 2021, he had actually checked himself into a substance abuse treatment center, which was with Lake Cumberland Recovery.
How did you find that out?
I believe his father contacted me and told me. They sent me a letter after I had requested it from a substance abuse treatment center. If it hadn't have been for his dad contacting me or the substance abuse treatment program contacting me, I don't know which happened first. If it hadn't have been for that, then I wouldn't have known where he was at. And ultimately, he would have been an absconder because Brandon himself had not been in contact with me at all.
Okay. I have no other questions. You're muted, Judge.
Your mic is muted, Judge.
Yeah.
The sheriff's office over there, would you flip your camera off?
Just text Scott or call them and tell them to turn their camera off.
Okay. Ms. Costello, do you have any inquiry here?
Yes, Officer Cooper, I'm going to kind of pick up at the end. You said that you received a letter from a treatment facility that Mr. Gadberry had checked himself into.
Yes.
Did he, to your knowledge, complete that treatment?
I have no way to testify to that. I don't know for certain if he did or if he did not. I do know that I contacted him while he was in the treatment facility to notify him that he had a warrant.
And after you notified him of the warrant, what did he, when was that, I should say?
I don't have the specific day in front of me. I do believe that I contacted him the day that he turned himself into the jail. I told him that it would be of his best interest to turn himself in this matter. I don't remember if he turned himself in the day that I notified him or if it was the next day.
Okay, but he did turn himself into the jail on the warrant?
Yes, as far as I know, he did.
Nothing further for this witness, Your Honor.
No other
Mr. Stockton,
questions.
no redirect. Okay, Mr. Stockton, would you like to be heard?
I'm sorry, it broke up. I didn't hear, Your Honor.
You said you had no other witness. You don't have any witnesses, Ms. Costello? I asked.
I would like to call my client, Your Honor. I'm
Okay,
sorry.
okay. Mr. Gadberry, you raise your right hand. You swear the testimony about to give us the truth, the whole truth, and nothing but the truth.
Yeah.
Okay, Mr. Cooper, will you turn your camera off? You can continue to watch. Okay, you may inquire, Mr. Costello.
Mr. Gadberry, you've heard the testimony of your officer and that you failed to complete the intensive outpatient treatment. Why did you fail to complete that program?
Well, Honestly, I was there, popped my leg out of socket. I don't know if it fractured or not at my hip. They wouldn't take me to the doctor or hospital, and I ended up leaving.
No, it broke up, so you may not have heard my question. Why didn't you complete the intensive outpatient program in Russell County?
I didn't. Only thing I know I had in Russell County was just going to counseling. I didn't know.
Yes. Yeah. Why didn't you complete that program?
I was still going to counseling up until I went back to rehab. I was going to a counseling place in Key Village in Russell Springs.
And what type of counseling was it? Did you call in over the phone or did you go in person?
No, I went in person.
Okay. The prior counseling you had been in, was that over the phone?
No, it was in person.
And then you checked yourself into treatment.
Yes.
And did you complete that treatment?
Yeah. The March 1st. They're supposed to be faxing you where I completed that.
After March 1st, what happened?
And I contacted Mr. Cooper myself the 2nd, and he told me about the warrant. I wasn't aware of no warrant until he told me about it when I called him the 2nd. And he told me to turn myself in on the 3rd by 4 o'clock that evening, or it'd be worse. But I turned myself in.
Okay. After you completed the treatment program on March 1st, if you hadn't had the warrant, what was your plan going to be?
Same thing, call Mr. Cooper, because I hadn't talked to him myself while I was in rehab. I told them I needed to contact Mr. Cooper. They asked me for his number, so they would call him for me.
Okay. As your living situation, were you going to stay in treatment or did you have another plan?
Well, when I completed it, my plan was to go to their sober living, which is in Somerset. There's a factory beside it within walking distance, and go to IOP 5 days a week.
And have you worked with anyone at the health department in Russell County to help you with anything?
Yeah, well, I was in rehab the Friday before I got out. I met a lady named Susan Hopper, and she's able. I ain't had no help for a couple of years. I've been bad sick with seizures and stuff. I don't recall even getting took to jail. But I've had no transportation, nothing like that. No way to get to doctors and stuff like I need to be. And I met Susan Hopper while I was still in rehab. And I guess she's a social worker. She worked at the health department though in Jamestown. And she said she could help me with transportation, work, just everything. She rescheduled me a doctor's appointment to get my head checked for my seizures and stuff. Just help me in all ways I've been needing help.
Nothing further, Your Honor.
Mr. Stockton, you want to inquire?
Just a couple of questions. Mr. Gadbury, when did you go to the Lake Cumberland Recovery Center and how long were you there?
It was sometime in January, and it ain't a long program.
So a little over 30 days, maybe?
Yeah.
And you said there's a sober living house up there. Is that something, when you get out of the jail, is that something you can go back to?
Yeah.
And you said it's next to a factory. What factory is close to it?
I want to say it's UGN.
Okay. I have no other questions, Your Honor.
Okay, is there anything else? Mr. Stockton, you want to be heard?
Your Honor, this is a case that presents an interesting quandary. I think Mr. Gadbury's conduct has been atrocious while he's been on probation. He didn't complete long-term rehab. He didn't complete SAP-OP. He's had 2 misdemeanor arrests for public intoxication. I will give him credit for checking himself into rehab. I don't know if the best solution is letting him go back to the sober living house and try to get his life straightened up, or revoking him. I don't know if he can comply with probation if he gets out or not, if he can keep in contact with his probation officer and do what he's supposed to. That's what he's been his main problem, it sounds like. And, so I don't know which is the best solution on this case. I know he's done enough to be revoked, but I'll do whatever the court thinks is best in this case. I'll go along with it.
Ms. Costello?
Your Honor, we would ask the court to let him return to or actually check himself into the sober living facility. I don't think he was ever there because he turned himself in. With him making contact with Susan Hopper and helping him with transportation, getting to his doctor's appointments, I think that will help a lot of his memory issues that he has and will help him maintain contact with his probation officer. And he has the support by going to the sober living facility, and hopefully the stability to show this court that he can do what he needs to do.
Yeah, I don't have in front of me. I notice in this 19 case that we're looking at, he was also, besides possession of methamphetamine, he was charged with probation violation for what were his previous felony offenses.
Give me his file here. Look at his criminal history. Your Honor, he's got a lengthy criminal history. Let's see any felonies. I'm just seeing misdemeanors. He's had felony cases in district court amended down to misdemeanors. And
Well, I
got
know, I'm just looking at the docket,
Yeah.
in the
He's got
docket. Go ahead.
He had a 07 felony flagrant non-support that was amended to misdemeanor. He's probably 15 or 20 misdemeanor convictions.
Well, on the docket sheet, it says possession of controlled substance, 1st degree. And then it says the second charge is probation violation for felony offense. That's what it says on my docket.
I don't think that's correct. He had, he had a receiving stolen property firearm also. And I think the only thing he was convicted of was the possession of controlled substance, because there was an issue with the firearm as to who the owner was and who had possession of it. I think that charge was dismissed.
Judge, if you look at the docket, it shows the charge date as 4/20/2020. So I think that is his current violation. That's just indicating that he's currently being held for a probation violation. Jessica could probably.
Yes, he was, the Commonwealth filed a motion to revoke April 20th of
So
2020.
we're talking about 19 CR 0024, correct?
Yes,
Yes.
that's correct.
Okay, well, okay, now, if you got my docket sheet there, it has 2/01/2018, and it's got possession of controlled substance. It's got April 20th, 2020.
Yes.
So that's his
Commonwealth
current violation.
filed a motion April 20th of 2020. That was denied in lieu of revocation. He was to serve 30-day sanction. He should
Okay.
reside at his brother's residence in Columbia.
Okay, I got you now. I
It's
got you
in
now.
his probation.
Well, it was
provider.
just so long ago. It's almost a year ago that motion was filed. Is why I found it a little bit confusing, And I guess we acted upon it. Is what you're saying. And now he's back again. How much time to serve does he have left?
Well, he's got a 3-year sentence. I don't know how much credit for time served he's got. Mr. Garner might be able to tell us. I don't know how much time he's got in.
I'd have to look that up, Judge.
Okay. Well, I don't really see any probability that Mr. Gadberry is going to be able to conform. I don't know, I don't know where his place in society is right now. I mean, he makes some effort. I'm sure he's got a problem, a drug problem. But I don't know. Letting him out, let him check himself into some place where he doesn't have to stay doesn't seem to put our hand on him enough to make sure he complies. Mr. Garner, do you have any suggestions on what you think the best way, short of revocation, would be to handle this gentleman? You've had, I listened carefully to your testimony.
I mean, Mr. Cooper. He's
It was
actually.
Mr. Cooper.
It was Mr. Cooper.
Yeah.
Yes, Your Honor.
He's going to be under Mr. Garner now, isn't he? Will he be under Mr. Cooper?
Well, I was just the supervising officer as a courtesy to your all's court since he lived in Russell County at the time.
Okay.
I'm willing to give any
Mr. Garner, but Mr. Garner was the one that'll have him now, isn't that right?
It all depends on if Mr. Gadberry plans on still residing in Russell.
Oh, I see. I see.
Or there.
Okay. Well, what do you think, Mr. Cooper?
Alternatives to revocation. I really don't know what alternatives we could exercise, because the only alternative that I would recommend, or not recommend, but the only alternative that I could see in a case like his would be inpatient treatment, which we have already tried and he left. He claims that he had a medical reason why he had left. However, I've never seen any medical documentation indicating that he ever got treated for an issue after he got released from that rehab. He may have that. I've never seen it. I don't know of any other options that we haven't already tried.
Yeah. How long has he been in jail this last time?
Said he turned himself in March 3rd. So it's been 21 days, 3 weeks. Has Mr. Gadberry ever been in a drug court program anywhere?
I am looking in CourtNet. I'm not seeing anything at this time.
I don't think so. Brant, Mr. Gadberry, have you ever been in drug court?
No. Well, I guess that's what I was first on, where you call in every morning.
That's reporting pretrial. That's not the same.
Other than revoking, that's the only option I can see. And if I was on a 3-year sentence, I'd probably rather go ahead and be revoked and stay in going to drug court, but that's not my choice. But drug court or revocation is the only thing I can see.
Well, I don't think it's right to make Mr. Gadberry make that decision without talking to his attorney. So I'm going to continue this case till I guess 22nd of April to let him decide. If between then and now they reach some agreement, Ms. Costello, with Mr. Stockton, I will consider sending him to drug court. But I want him more closely supervised than just saying he's going to turn himself in and live next to a factory and be out there on the street. That ain't going to happen. So y'all keep me in contact. Is he on the state dime or on the county dime right now?
We'll need to enter an order in lieu of revocation until next month when it's reviewed, Your Honor.
Yeah.
And then you can decide what to do.
As of right now, Cumberland County is basically paying Adair County for him to.
Okay, you need to probably put a PIN number in on him and see if we, in lieu of revocation. Can you do that?
Yes, I can, as long as an order is drawn up saying that he is serving sanctioned time until his next hearing or something like that.
That's
Okay,
what we're
well-
getting ready to prepare.
Okay,
Okay.
thank you.
All right.
Thank you very much. Yeah.
So he is not revoked just yet, but
Not yet, but we're going, he's going to be in jail until we decide. And then
okay.
if he appears that he's qualified for a specialty court or drug court, we'll try that with a bunch of different conditions on it. And,
Okay.
that's the last thing. I mean, it appears to me that he hasn't been convicted of anything other than the possession of methamphetamine. That's a felony according to the information that I have now. He just hasn't been compliant. I don't know how much he understands about what's going on, quite frankly, but that's the reason he talked to his attorney. Okay. You understand what
I
I'm
do-
saying, Ms. Costello? You understand what I'm saying?
Yes. Yes,
Okay,
Your Honor.
thank you. Next case is Commonwealth versus Higginbotham. Caitlin Page Higginbotham.
Judge, her attorney called. He's working as.
Yeah, he's going to appear by phone, I believe.
Is that okay?
Yeah, that's fine.
Okay, I'm gonna call him. Judge, when I call, it just says the wireless customer you're calling is not available. It don't ring or anything.
Miss Megan, could you see if you have a number? How have he's contacted you earlier? Megan, are you on there?
I contacted her about it, so I don't know. I can call his
Okay.
office.
Okay. Well, we'll pass over this case. The next case is Landon Kirk. Commonwealth versus Landon Kirk, 19 CR 0069. Are you Landon Kirk? Okay, you're gonna have to speak up a little bit.
Yes, sir.
Okay, that's good. Thank you. Are you born in 1992?
Yes, sir.
Last four digits of your social security number or what?
0395.
Okay, we're here today on a motion to revoke pretrial diversion. Is that correct?
Yes, sir.
Mr. Stockton, will you go ahead? Ms. Costello, you represent this gentleman? Okay, Mr.
Yes, Your Honor.
Stockton. Your microphone's off, Mr. Stockton. So,
Mr. Kirk was charged with assault, 4th degree domestic violence in Cumberland County. He was also charged with a new felony, intimidating a witness in the legal process. Evidently, it's alleged that he made statements to the witness that she better drop the charges or else over a 3-month period. The only witness I would have would be the witness, the lady that he allegedly intimidated. And I had my detective check on the case, even though this happened back in December and there has been an arraignment date set. This case is not scheduled to come to court in Cumberland District Court up until April the 21st for arraignment. So I'm at a loss as to why this case has not progressed any over the last 4 months. And I'm not prepared to go to court. I can subpoena, if you want to set us another day, I can subpoena Cheyenne Phillips, I think's her name, for a hearing, but I have no other information other than that.
okay, well, you want to continue he's in jail now on this case or on something else?
He's in jail. I don't know if anything else is holding him or not. Mr. Garner
Your
may
Honor.
know.
Your
I
Honor,
believe sorry.
apologies. I didn't mean to interrupt. This is the gentleman that I drug tested on the 10th of March, and I consulted with Your Honor about, and he was on home incarceration, and you said because he was using, he admitted to using methamphetamine, and because he was using methamphetamine while on electronic monitoring device, you had me lodge him until you could see him in court.
Okay,
So if you want to have a hearing next week, I'll try to locate this lady and get her on Zoom or whatever, if you want to wait till next month. But I was kind of at a loss till I could get Mr. Vanderpool, and I'd try to figure out what was going on with that case in district court.
well, I'll continue the case until April the 22nd. And Ms. Costello, if you can find any information out or reach some kind of agreement on a bond. I previously obviously revoked the previous bond, had him taken back in when he failed a drug test or made an admission, I guess it was. So,
We need to subpoena her for that day.
okay. That would be April the 22nd, unless there's some agreement as to how he might be released, and we have some certainty that there's not a continued violation of the conditions of bond. Okay, thank y'all very much. Jason Floyd Norris. Jason Floyd Norris.
Judge, I think he's in the Dare County Jail.
Okay. Okay, thank you. 17 CR 0002. Are you Jason Floyd Norris?
Yes, sir.
Okay, we're here today on a motion to revoke pretrial diversion. Mr. Stockton, you want to proceed?
Your Honor, Mr. Norris is on flagrant non-support, 3-year sentence. His last payment was August 17, 2020. He's supposed to be paying $197 a month. He currently owes $3,846.02. I think Ms. Costello has a proposal in this case.
Ms. Costello?
Yes, Your Honor. Mr. Norris, and I spoke to Mr. Stockton about this yesterday. He does stipulate to the violations. He would like to be referred to the drug court program. As far as catching up his child support, Mr. Norris indicated to me that he has to file his taxes for this year I apologize, file his taxes for last year. He never received any of the stimulus checks and would have qualified for them. So if he gets his stimulus checks through his taxes on the tax rebate for the stimulus, I don't know the official term for it. I apologize, Your Honor. The stimulus alone would equal $3,400, and he would take that entire amount and place it on his arrearages that is owed.
That sounds real. Let the taxpayers pay his obligations of him paying it himself, is what you're saying?
Well, it's his
The
stimulus that he
taxpayers.
would qualify.
It's the taxpayers, yeah. Okay.
And then the remaining amount of his taxes, he would also pay up. So through that, and he believes he would get more than $400 on his taxes.
I'm sure he will.
Then he would pay that arrearage amount in full and enter the drug court program and resume making his monthly payments. He also
Yeah,
had
Mr.
a
Norris,
job-
can you care if I ask Mr., are you willing to give the drug court a try, the specialty court?
Yes, sir.
Okay. Well, you're still a young man. It's not too late for you to turn your life around and be free and have a productive lifetime. So you agree with that, Mr. Stockton, you say?
Yeah, two things. I would ask that he stay incarcerated until he's oriented for the specialty court program. And
Yeah.
two, I think that I would need some documentation from his attorney showing how much money he's getting back, and then that would be applied to the child support obligation.
I wondered if they can do intercepts on that. They do it on regular tax.
No, not this last group. They can't. That's one of the provisions under this that you can't intercept the money. So
Yeah.
want the people that get the money rather than maybe victims out there.
Yeah, I understand. Okay, y'all submit me an order and we'll get you on the road to that, Mr. Norris. I hope you comply with it. Thanks around for you, okay? Commonwealth versus Christian Tyler Parish.
I've got it.
Judge, I don't believe the jail is on there yet. I think they had a hearing before this one.
Okay,
Oh, I'm sorry, there he is.
there he is. Okay, Mr. Parrish, you can remove your mask, I think, if you're away from everybody else.
I'm in a casework area here at the prison, and I'm not allowed to remove it, Your Honor.
Okay, which when she said the jail, I really didn't know where you were. Okay.
I'm in LaGrange.
Okay. Commonwealth versus Christian Tyler Parish, 19 CR 00100. Mr. Simpson, you brought a motion for shock probation. Is that correct?
I did, Your Honor.
Okay, you can proceed.
Your Honor, first of all, thanks for hearing us today and making sure that Tyler could be online as well. We, as you'll recall, when Tyler was sentenced, Your Honor, we did not ask for probation or ask you to even consider probation at that time because really, Tyler told me he knew it was not the right thing to do and he wanted to wait until the very last moment that he could possibly file to ask for court's consideration. And that's what we did. We are now at either close to, at, or past 180 days where the court would lose jurisdiction. One of the things that I want the court to know, and I'll have him, if the court will allow him to address the court here shortly, is that he knows the pain that he's caused the Arms family. He knows the pain that he's put his own family through and has never taken this lightly whatsoever. So one of the things that I did was I submitted to the court a series of letters. I think there are 14 letters, Your Honor, that we sent to the court. And as I read those letters, and I read every one of them, every word, I just thought, boy, I hope that I would hope that if I got in a situation or someone came to my funeral, they would say these nice things about me, because it says a lot for Tyler to have those people say what they said about him and what a nice young man. He's had some challenges in his younger days growing up. but he seemed to have overcome all of those when this hit. But the one thing that sort of struck me throughout all of those letters, Your Honor, was the fact that family and God are the two things that really are the center of this young man's life. And so, you know, everyone's life changed that night. And certainly Tyler understands that. So when I started looking back through the file and sort of putting together the timeline that I painstakingly put in our motion, Judge, you'll see in there that what was going on was that Tyler was trying to be a good brother. He was trying to be a good grandson. He was trying to be a good cousin and an uncle. He was running all over creation between living in Bowling Green, working in Russellville, and having family back over by the lake, and going to graduations and things of that nature, that he just had burned the candle at both ends. And the night that this all happened, you know, he wasn't involved in a high-speed chase. He wasn't fleeing from a domestic violence scene or something of that nature. He had gone down.
Mr. Simpson, let me interrupt you here for, you know, you're making these statements. I don't doubt that you believe those statements, but I have to make my decision, not just on your argument, but upon facts that are in front of the court. And I don't have any testimony to back up any of the things that you're talking about. You know, this, as you know, this case was done through mediation.
Yes, sir.
Very little, if anything, about the underlying facts of the case.
Well, I can have Mr. Parrish testify about.
I think it would be helpful.
Yes, sir. I'll be glad to.
You think so, Mr. Stockton, or what?
Whatever is helpful to the court.
You know,
sure. I'll be glad to call Mr. Parrish.
Well, the thing about it, if we're going to do that, we might need to go to the end of the docket, because we got all these other people waiting here.
And that raises the question, do I need to call the victims in this case because I attached letters to my response? You know,
I've read all the thing about it is, I understand this. I don't think we ought to retry this case. Is what I'm trying to get to. There was a mediation. There was an agreement. Okay. And the Commonwealth said in their agreement that they were going to oppose shock probation or probation, and you didn't make any commitment that you weren't going to try for either one of them. Now, I'm correct that way. So both of you just doing your jobs here. I understand that. But I don't really want to get re-involved in retrying the case. I've read all of the letters. My staff lawyers read all of the letters. There have been victim statements again filed in the case. So if you want to, I don't necessarily need to hear the accused. I heard what he said. He was, he accepted responsibility for his actions at the sentencing, apologized to the family. I heard all that. I think it was, I have no doubt it was sincere. Is there anything you want to end up saying, Mr. Simpson, before I let Mr. Stockton have a say here?
Well, Judge, and I agree. I don't want to retry the case. But I think Mr. Stockton, I don't know that he really disputes some of the things that I'm saying as far as where Tyler was coming from that night, which was sort of where we were. There was not any of those things going on. He was coming home from one of the marinas where a cousin was playing music, and that's the point I was making.
Well, the issue is that he was under the influence.
Yes.
Where he was coming from, he could have been coming from a church fish fry if he was under the influence. So, that's the bottom line of that.
Yes, sir.
And he acknowledged that. Do you have anything else you'd like to finish up in? I have no doubt that he was a good brother and was a supportive cousin. I don't have there's nothing to the contrary of that. He just made a terrible mistake, which he's admitted to.
I think Tyler would like to address the court, if he may, Your Honor.
Well, I'm going to let Mr. Stockton
respond. And I do have some more argument after that.
Well, go ahead with your argument then.
Okay. And I would like Tyler to address the court, but Judge, you're right. We did we did do a mediation in this case. And I think it's significant that the murder charge was amended not to wanton murder or something like that. It was amended all the way to a Class D felony, reckless homicide. It's not even manslaughter. And so,
Your Honor, I'm going to object to this line of argument. You know, the mediation was confidential. We're getting into things that, you know, what the charge was. You know, he's got a 10-year charge. Whether it's manslaughter or reckless homicide, I don't know that makes any difference. You know,
yeah, I'll just state what's the public record is that he's convicted and pled
Well,
guilty to reckless
I'm going to
homicide.
object to the way you're characterizing it.
Well, he's convicted of reckless behavior, Judge, that resulted in the unfortunate death of the Arms, Mr. and Mrs. Arms. So my point is that, you know, when Tyler was sentenced, he was in the Adair County Jail for a while. He's transported. He's been in prison, which is no small thing. And his sitting in prison, based upon the letters that you've seen, and I think that Tyler's reputation is well known in the community as being a fine young man. His prison stint is not going to rehabilitate him. He didn't need rehabilitation. He committed an act that night that just was devastating. And it was an isolated incident, to say the least. It will only
How do you know it was an isolated incident? I mean,
because of his criminal history.
Wait a second. You're testifying. I tried to lead you away from testifying. I mean, I don't need to hear your testimony. I think a lot of you, but what you say is not a fact. You're making arguments that he should have leniency, and I understand that, but you don't need to try to make these factual statements about his prior conduct or anything like that unless you want to be sworn and be a witness.
Judge, I'm just basing that on his criminal history.
Well, okay, you want him to be heard. I think he has every right to be heard here, and you just tell me when you want to hear him.
I would like for him to address the court now, if he may, Your Honor.
Okay, you want to raise your right hand, sir? Do you swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, thank you. You may proceed to inquire, Mr. Simpson.
Thank you, Your Honor. Would you state your name for the record?
Christian Tyler Parrish.
And would you tell the judge where you're currently located?
I'm in a SAP program at LaGrange, Kentucky.
And as I understand it, your case was recently reviewed by the parole board. Is that correct?
Yes.
And what was the result of that? What was the
they
outcome?
gave me a 24-month deferment, so I'll be going back up May of 2023.
Okay. Tyler, will you briefly tell the judge what you want to tell him regarding that night, your state of mind, and then what you've learned from this, and any other expressions you want to make to him or the Arms family?
So the incident at hand, I've always taken full responsibility for that. I've not tried to excuse the actions or belittle them or anything. I made bad choices, and they resulted in terrible consequences. And it's something I focus on a lot since I've been in here. It's something that little moments in life triggering me now that I can't enjoy certain things because of it, and I'm not making excuses for that. That's just how my life is now. But since coming to prison, I've got to witness and see a lot of things that you normally wouldn't see out on the streets that are very, very terrible. But I don't want to excuse my behavior. I want it to serve time, and I want to make amends with my situation and the harm that I've caused. But I feel like I could do something better, more worthwhile than being sitting in here. I feel like I've got more potential for my community or for something with my church that I could do, or anything that would be more beneficial than sitting in.
How long have you been at LaGrange now?
I came on November the 24th. the day before Thanksgiving.
Okay. Anything else you want to add?
That's the gist of it. I mean, for the most part, I know I've done wrong, and I know people hurt, and I can't take it back as much as I wish I could, because I hurt more than 2 families that day. I hurt a whole community and people I love. But my only argument to it is that I just feel like I have a lot more potential I could offer than sitting in here. I don't feel like Kristen's really going to make me better as a person. I've used the opportunity to help other people in here become better. Make them aware of a lot of people in here like to gloat about their crimes and stuff. So I've had opportunities to talk to people about their situations and stuff. So it's been a blessing in the midst of turmoil, but at the same time, I don't know. I just feel like I have more potential than that.
All right. I have no further questions.
Mr. Stockton, would you like to inquire?
I do not have any questions.
Okay. Do you have any other witnesses, Mr. Simpson?
I don't have any other witnesses, Judge. I would like to add one thought here. When every time I make an argument for shock probation in difficult cases, I recognize and realize that the court's hardest job and the hardest job of a judge is what I've been watching you do here this morning. You try to figure out which people you can take a chance on, which people you can trust to not reoffend. That's the hardest thing to figure out. I think we could all sleep well at night knowing that if you granted Mr. Parrish shock probation or shock probation with some other alternative sentence, that we'll all be able to sleep well at night. This young man is a fine young man who made a horrible mistake. And Judge, I do not believe that granting him shock probation at this time, given the circumstances, would unduly depreciate the seriousness of this offense. Like I said, it's the hardest job a judge has to do, is to try to sort out the ones who will never be rehabilitated from the ones who have something to offer the community. And Christian Tyler Parrish is that young man who has a lot to offer and will never harm another soul his whole life.
Mr. Stockton?
Your Honor, I'll be brief, and I don't mean to disparage Mr. Simpson or Mr. Parrish, but the way I read their argument and understand it is I take full responsibility. I've done a horrendous thing, but punish me just as little as possible. And I don't think that cuts a lot of weight with me in this case, because I don't think the focus should be on Mr. Parrish as much as it should be on Mr. and Miss Arms, who are now deceased, and upon their family. The court's right. We had mediation. We reached an agreement. Part of that agreement was the victims going along with it. And the 10 years was part of that. The fact that we would oppose shock was part of that agreement. Recently, there was a parole board hearing, and the Arms family was able to participate in it, and Mr. Parrish was given a 24-month deferment. The way I have this figured is Mr. Parrish has spent a little over 6 months in jail on this case. He had all this home incarceration that he got credit for. That's a battle I'll fight another day. But needless to say, he's been in jail for his actions causing the deaths of 2 people for just a little over 6 months. That'd be about 3 months each. That's about what their lives would be worth if the court shock probated Mr. Parrish. I just think that would be a kick in the teeth to the Arms family and the Cumberland County community, because that would belittle their lives. That would belittle the care and affection that the Arms has had for their mother, father, and grandmother. And the Commonwealth is opposed to shock probation.
Mr. Simpson, would you like to respond to that briefly?
Because I cannot imagine what the Arms family has gone through. And certainly our motion is not meant to insult them in any way. We're back to the point, would shock probation unduly depreciate the seriousness of an offense? It's just sad all the way around. The Arms family have been turned upside down. Tyler's life's been turned upside down. I don't think, as Tyler said, I don't think there's anything for him to learn in prison other than see the horrors of what prison is like. And he's gotten a really good taste of that, it would appear from what he said earlier.
Yeah.
And so I would ask the court to at least, if not outright shock probation, to consider some alternative sentence, because I don't know that anybody would have expected the parole board. And of course, we never know what the parole board's going to do. We advise clients accordingly. But in another 2 years, because you're his last hope, Judge, another 2 years in prison is not going to serve the interests of justice. It's just going to punish Mr. Parrish. Is all it's going to do.
Yeah.
Just add that sometimes justice causes punishment is part of justice. And that's the Commonwealth's point in this.
Okay, well, thank both of you for your argument. I don't think it's unusual, Mr. Stockton, actually, for people to come in front of the court and defense attorneys to come in. I've done my action, but I want as little time as possible. I think that's part of their, that's not an unusual thing. I read all the letters and I was touched by many of the letters. Both sides. I have no doubt that Mr. Parrish is an outstanding, is an outstanding young man. Seems like a lot of people think that, especially people that are around his church. Quite frankly, I learned about the deferral of the parole board when I was trying to get a calculation done on how many days to see if this was properly in front. When I received one of these motions, we always do that, we pulled up and found out. I couldn't, considering the actions that I see with the parole board on a lot of other things, a 24-month deferral on any Class D felony seems unusual. I think Mr. Stockton would agree with that, but it made me reflect upon what these people that see these cases all the time think about the underlying facts of this case when they read the pre-sentence investigation report and other documents that they have, and how indeed fortunate that Mr. Parrish was that he was able to have you negotiate this plea to him and take Class D felonies. But one of the reasons, I'm sure the Commonwealth agreed, is that there was a 10-year sentence involved. It wasn't whether they were Class C or D. I mean, it was 10 years. And knowing this community the way I do, and the connections that both families, the victims are, they were highly thought of. Mr. Parrish has family members that are highly thought of, and it would have been very difficult to have had a trial. I think Mr. Stockton would agree with that. It would have been very difficult. And I think you'll agree with that, Mr. Simpson. So y'all came together and you reached this agreement. And part of the risk that, that Mr. Parrish went with is that he wouldn't be granted probation or shock probation, or that the parole board. Now, I was surprised that the parole board had acted on it. I thought that I would have to make this decision prior to any parole board things, but evidently, when we looked at the situation, it seems that the process is they bring them up about 2 or 3 months, maybe before they're eligible for parole. In this case, that's what they did. One of the purposes for the criminal justice system is rehabilitation, and I have no reason to believe that Mr. Parrish is not, accepted his responsibility, and that he's rehabilitated. He's thought about all, he understands the area's ways. But the other thing is to let people in the community know and the public know that there are consequences for their actions. We've recently had another vehicular homicide charge here in Cumberland County, or it appears that's what the charge is. And you see those around. People have to understand, not just Mr. Parrish, what he understands, but the criminal justice system has to set standards for conduct in the community. And it's just not acceptable for people to be on the highway under the influence of alcohol or drugs and to take these innocent lives. So I appreciate your arguments, Mr. Simpson. I appreciate you're willing to accept responsibility, Mr. Parrish, for your actions. And it is just, I believe, my responsibility to deny this motion for shock probation because the plea was negotiated, and the parole board, I think, represents the public also when they make their decisions based upon all the evidence they have. And really, many times, usually, if they err, it appears to me, many times they, in the public's opinion, they err on being too lenient. And in this case, if you review the case, I just can't, Mr. Parrish, there are a lot of people that are spending 20 years in jail for the exact same actions. Your attorney did an excellent job for you, and you were fortunate enough to have the family support to hire an attorney that has got good reputation as far as a criminal defense lawyer, and you presented yourself well. And I'm sorry that you're in this situation, but you and I both know that it wasn't me that put you there. And so I'm going to deny this motion, and I that you spend this 2 years, if that's what you have to serve, if the parole board doesn't take any other action in a constructive manner. Thank you all for the presentation of the case.
Thank you, Connor.
Okay, the next case is Commonwealth versus Jacob Scott.
Judge, that's my case.
Are you Jacob Scott? This is 17 CR 0013. Commonwealth, Kentucky versus Jacob B. Taylor Scott. Mr. Scott, were you born in 1991? Okay, now you're gonna have to speak up a little bit, okay?
Yes, sir.
Okay, thank you. Okay, this is a motion to revoke probation. Mr. Stockton, what do you have here?
Your Honor, Mr. Scott has a 5-year sentence for fleeing and evading police, first degree. And
Yes.
He has a new felony arrest. And I'd be calling Lance Watson, the arresting officer, as a witness.
I would assume you don't want to stipulate, is that right?
Judge, I was going to ask the court, having just been retained in this case, if we could put this to the April 27th date so that I can further speak with the Commonwealth about a possible resolution on his newest case and maybe a disposition of this revocation.
Well, I anticipate Mr. Scott being indicted before the next April rule day, so I'll defer to the court, whatever he wants to do on this new case. Since
Well, if you think there's going to be an indictment for the purpose of judicial economy and to give an opportunity to wrap all this stuff up, I think it would be it would not be inappropriate to continue the case until April the 22nd. When do you anticipate the grand jury will meet?
Well, it'll be that day.
You're going to do it on that day.
I would say May might be the best day to review.
Well, what I was going to do is if you're pretty confident of the fact that an indictment would be returned, if you start negotiating with Mr. Garrett, we might proceed by information on the new charge and wrap it all up on the 22nd. And if you can't do that, we'll let the grand jury do what they want to do that day and proceed accordingly. Okay.
Okay.
Okay,
I think that's a good idea.
Okay, April the 22nd.
Thank you, Judge.
Yeah. Mhm.
Have a good day.
Yeah. Thank you. Starting off pretty rough, but things can improve. Joseph Slayton.
Thank
you. Yeah. Commonwealth versus Joseph Slayton.
Judge, I believe he's in Barron County Jail, but I don't see them on here. I'll try to get a hold of them.
Okay.
I printed off some stuff on Danny Staten yesterday.
Okay. Danny Staten, Commonwealth versus Danny Staten. Do we have Danny Staten on the line?
Judge, he's in Adair County Jail.
Here he is.
Okay, Commonwealth versus Danny Staten, 20 CR 00020. Ms. Costello, this is Danny Staten. Mr. Staten, were you born in 1959?
Yeah.
Last four digits of your social security number are 7826?
Yes.
Okay. You have a motion to reduce bond?
Yes, Your Honor, I have a motion to reduce bond in all three of his cases and a motion to suppress in 20 CR 20.
Okay. Well, let's do the motion to suppress first. Mr. Stockton,
Your Honor, he has 3 pending cases. That will be the last case tried if we try his case. I've got a criminal syndicate case, receiving stolen property, which will be tried first. I don't.
okay, well, we'll just defer that motion, let you reserve the right to challenge any search that was there until it becomes appropriate that he might be tried on that case. Now, the next thing you do is a bond reduction, is that case? Ms. Costello?
Yes, Your Honor, I filed a motion for bond reduction in 20 CR 2020 as 20 CR 21 and then 20 CR 70.
Yeah.
We are asking the court to reduce Mr. Staten's bond to a single bond for all 3 cases. Spoken to him, he believes that he could potentially post a property bond, but it's 10,000 cash or property.
What is the bond? What is the bond now?
I thought it was 50,000 property when we checked.
I believe so. He's been
I don't think that that's a very high bond, really. Considering all the charges, of $50,000 property bond.
Well, Your Honor, I believe it's 50,000 cash or property, so the value of the property would have to be 100,000, and he's been unable to post that, which is why we were asking the court to consider a reduction at this time.
The last bond decision that I have says 50,000 property bond with ankle monitor.
Yeah. Mr. Stockton?
Your Honor, I'm prepared. I've got Mr. Kenny Brown ready to testify about an undercover drug buy that occurred back in March of last year. I've got Sheriff Daniels prepared to testify about the criminal syndicate case. I've
Okay,
also.
well, let me ask you about the undercover drug buy. Is an unindicted act?
That's correct. He'll be indicted in April.
Okay, well, I think that we ought to proceed on this case the same way we did on the other. If Ms. Costello shook her head, she seems to be aware of that. Are you aware of that, Ms. Costello?
Your Honor, I was aware of a pending case.
Okay, so now that that's kind of out in the open, Mr. Staten, that there's a undercover drug buy that they're going to allege, don't say anything one way or the other. I think it would be in Mr. Staten's best interest for that information to be provided to Ms. Costello by form of information. You're going to take it in front of the grand jury on the 22nd. Is that correct?
Yes, Your Honor.
Okay, so let's do the same thing on this we did on the other case. Once you present this evidence, it might be possible to roll all this stuff into one. And if it's not, then on the 22nd, I can we'll set a trial date. Is this one of your top priority cases?
It is, Your Honor, because I will tell the court Mr. Staten's on parole, and he has a minimum expiration date of 2028 and a maximum of 2038 because he has so many felony cases pending. I do not see that this case being resolved. We'll have to have a trial.
Yeah. Okay. Well, we'll set a trial date then, and that way there's no need to subject the officers to cross-examination or anything on this case until the case goes forward. So we'll do this on the 22nd. We'll see if the indictment comes down or if you've entered any resolution. So what you're saying, because of his parole situation, he'll be eligible when?
He's got anywhere between 6 to 15 years left to serve out on his previous felonies. And so I've been advised by Ms. Costello, there won't be any pleas in these cases. We're going to have a trial. So
Is that right?
that's,
Is that right, Ms.
In
Costello?
in the current cases, I believe we'll have to have a trial, Your Honor.
Well, that's the only ones I deal with is current cases. Those other cases I don't deal with. Well, we'll know more on the 22nd when we can set trial dates anyway. And we'll set the trial dates on the 22nd. Okay, thank y'all very much. And was there a case we had to go back to? These officers can be excused, is that right?
yes.
I guess we had the case of Caitlin Hickenbotham.
Yes, Judge, I've got a number to call him again.
Okay.
Danny's.
And we also had the case of Joseph Slayton, is that correct?
Judge, I got him on speakerphone.
Okay, we need to get Caitlin Hickenbotham on back up. Caitlin Hickenbotham. Where is she?
She's in Wayne County Jail.
Wayne County.
There she is, Caitlin Hickenbotham. Okay, this is 18 CR 0083, Commonwealth of Kentucky versus Caitlin Hickenbotham. We're here today for sentencing. Your attorney's on the line. Counselor, would you identify yourself online? Yeah, I can't hear him. Hello? Mr. Wittenberg?
Yeah, I can hear you, but I'm having a hard time hearing him.
Hearing who?
He's having a hard time hearing you, Judge.
Can you hear me, Mr. Wittenberg?
I can when you speak up real good, I can hear you.
Okay, Mr. Wittenberg, I want to tell you something. We're here one day a month, and you can have another job if everybody has to make a living. But from here on out, you need to schedule around this day if you want to practice in this circuit. You understand what I'm saying? Are you there?
Are you still there? Says call failed.
Yeah.
Hello, this is Stephen Cousins. I'm sorry I couldn't get to the phone.
It went to voicemail. Well, they're calling back. Okay, Judge, he's on the line.
Okay. I'm ready now. I don't know what happened to the phone.
Where are you, Mr. Wittenberg?
Yes.
Can you hear him?
Mr. Wittenberg. Where are you, Mr. Wittenberg? Why aren't you in court today?
Judge is asking why you're not in court today.
Issue a bench warrant for Mr. Wittenberg.
Okay.
And Mr. Wittenberg is going to be arrested. Mr. Wittenberg, I'm issuing a bench warrant for you. You were scheduled to be here today in court, and your client is here in jail for a sentencing. And if can you hear me?
I can hear you, Your Honor.
Okay, where are you located now?
I'm actually in Livingston, Your Honor. I'm in an EMT bus. They had scheduled me to work prior to the court stuff, and I tried to get somebody to fill my schedule.
Well, let me tell you something. I'm on the edge of issuing a bench warrant for you. This case has been scheduled for a long time, and your client's over there in jail. And there's a pre-sentence investigation report. We try to get a hold of you. You're fading in and out, and this is not acceptable. Do you have any good reason why I shouldn't have you arrested?
No, I don't have any good reason, Your Honor. I mean, I tried to reschedule it. I don't know. I should have done something. I'm not going to make any excuses for what I've done. I've failed the court, Your Honor. I mean, I fully.
Okay, well, I'm going to find you in contempt of court. I'm going to fine you $500, and we're going to reschedule. Have you talked to this client here about this pre-sentence investigation report? Have you consulted with her and done your obligation and due diligence on this?
Yes, Your Honor.
Okay. Ma'am, your attorney is here on the phone. Are you willing to go ahead and proceed with this?
Yes, sir, if you will allow it.
Okay. Have you had plenty of time to discuss this matter? And have you reviewed this pre-sentence investigation report done by probation and parole?
I filled out my probation and parole paperwork. I have not seen the paperwork.
You haven't seen the report? No. You haven't gone over the pre-sentence investigation report?
No, Your Honor, I've not seen that.
Well, I can't sentence you today. Mr. Wittenberg, why haven't you gone over the pre-sentence investigation report with her?
Judge, he's gone again.
Get him back on the line.
Okay, I'm trying. It says call failed.
Your Honor, Ms. Higginbotham's clearly distraught. I don't care to reschedule this at the court's convenience. If you want to do it next week, anytime, I'm available.
Well, here's the problem is she was supposed to be pretrial diverted and let out of jail today. Is that right?
Now, I was going to oppose probation based on her past conduct, but that doesn't mean she shouldn't have her day in court.
Well, I know, but it was was she supposed to be pretrial diverted?
She was revoked on a pretrial diversion where she was in drug court and was terminated.
Yeah. Okay.
Judge, the attorney's back on the phone.
Well, see, it had sentencing on the docket here, and this is not a sentencing, right?
Yes, it is. It is, Your Honor.
Yeah.
She was revoked.
Pretrial diverted and voided.
Yeah, it is.
The pre-sentence investigation report the pre-sentence investigation report wouldn't have been done until after I revoked her pretrial diversion set aside. So I'm correct that she hasn't seen this pre-sentence investigation report, what I'm getting to. If we were trying to revoke her probation, then she would have seen this thing back when she was sentenced. So this is a sentencing. It is correct.
You're correct. Yes, sir.
Okay. Are you on the line, counselor, now? Why haven't you gone over this pre-sentence investigation report with your client?
I didn't fully understand what you said there, Your Honor.
I asked her if she had seen the pre-sentence investigation report that she has to review before sentencing.
No, Your Honor, she has not to my understanding.
Well, that's your responsibility to make sure she sees that and goes over it. So not only did you not appear here today, you didn't.
It is, Your Honor.
Are you acting as private retained counsel, or is this a conflict?
I am, Your Honor.
Okay.
I apologize for being upset. I'm 6 months pregnant. I can't hold it in.
Well, here, it's not, okay. I'm going to reschedule this for April the 22nd. And unless, Mr. Stockton, you can get the defense counsel, and I'm fining $500 and taking under advisement whether there's going to be jail time involved. This is a gross failure to represent someone, not to present this pre-sentence investigation report, and then not to appear in a situation where someone's facing 3 years in jail in this situation. So I'll reschedule it for April the 22nd.
Thank you, Your Honor.
That's all we have here at Wayne County for you, Judge.
Well, it's been a pleasure being with you today. Thank you. You're always very helpful. You have a great day.
See you, Jesse.
Joseph Slayton.
Judge, he's in Barron County, and there's Barron County Circuit Court going on right now.
Who's his attorney? This is a pretrial conference. He's not here today. We're not going to take any action on it of any kind. So let's just continue it because of his unavailability to April the 22nd, okay? And then that day we'll find out whether you're going to enter a plea. I think some people might be more interested in negotiating once they see trials being set. Not that you're one of those people, Mrs. Costello, but there are some that are like that.
I understand, Your Honor. And we are working towards a resolution on this, so that
Well,
will
it's hard to work toward a resolution if there's not any consequences out there, you know. Is there anything else to come before the Monroe Circuit Court Criminal Division?
I thought James Whitlow was on. Is he not on the docket?
He is, and he's also in Barron County.
Oh, okay. So we can continue to do.
Yeah.
He's a pretrial.
I also have a motion for me to recuse filed in 20 CR 0027 here. I'm a little confused. Are you the prosecutor on that case, Mr. Stockton?
I am.
Okay. Well, it was filed late, but we'll go ahead and proceed on that since we're here, and I see Counselor on there, Mr. Sims on there. Have you received a copy of the motion, Mr. Commonwealth Attorney?
I got it late yesterday, Your Honor.
Okay, now do we have Mr. Riddle online?
Judge, he's in Adair County. I can get them back on.
Yeah, call up there and see if they can get him online. We'll just.
Okay.
What did we do?
Judge, Mr. Whitlow, he's just on for pretrial. Was you wanting to continue him out to April also since he's in Barron?
Yeah, continue him to April because of inavailability, and we can't set trials right now anyway.
Judge, they're going to get him and get him on, okay?
Okay.
Welcome.
He is, we just, oh, we did an
Hello? It appears that we have a dare on the screen there. There you go. Do you have Jonathan Riddle?
Yeah, they went to get him, Your Honor.
Okay, thank you. This motion was not timely filed, but I just decided to add it to the end of the docket. So that's the reason you didn't have it. So it's no problem that you've caused, okay? Y'all are always very cooperative. Okay. Commonwealth versus Jonathan Riddle. Are you Jonathan Riddle?
Yes, Your Honor.
Okay. Now you have a motion, Mr. Sims, in this case, but before we go there, I'm a little confused about these various cases that we have. Mr. Stockton, are you back with us?
I am.
Now you are, Mr. Riddle's got some cases that you're not on. Is that correct?
He has an, oh, I didn't mean to interrupt you, Mr. Sims. I just going to say the Cumberland County case where he was placed in drug court was transferred to Adair County.
Okay.
That's in the Adair Circuit Court. That's the only case I'm aware of that's not in Cumberland County.
But you're not the prosecutor on that.
I am not.
So when it was transferred up there because his sister who's the district judge, is running the drug court here, the case was transferred up there, and then stayed up there when he absconded.
That's correct.
Okay. And so, Mr. Sims, you got 20 CR 0027. Is that the burglary case?
Yes, Your Honor. That's the case wherein the defendant is charged with burglary and a couple
and then
of other.
18 CR 0049. What was that case? You make it, that was the one he was, is 18 CR, is that the case he was in drug court on up in Adair County?
Look. Let's see. Maybe Miss Milam could tell us the case number in Cumberland County that was transferred to
Yeah, what is, Ms. Milam, what is 18 CR 0049?
Let me get in KY courts real quick.
Yeah.
It's a possession of controlled substance first case, and then
Court net is showing that is the case that's transferred, whether court net's correct or not. That's what it's
Okay,
showing.
okay. Well, was it still here then when he appeared in court on this other thing, or?
I believe so, Your Honor. The court
think
net
it was.
indicates.
When I'm talking about on April 25th, 2019, when you say
Court net shows that he was in court April 25th, 2019, in Cumberland County.
On which charge?
On 18 CR 00049.
Okay, so he must not have gone to drug court at this time. Go ahead with your motion. I just want to get those things clear. I've read your motion, and in particular, you take issue to the fact that in court on April the 25th, I directed that there be some investigation by the Commonwealth attorney as to why no action was taken when he left the Justice Center and evidently eluded or was accused of eluding and fleeing. Is that what your problem is?
No, Your Honor, not exactly. The issue is not that the court asked for investigation. The issue is that on the recording, the court specifically directed the Commonwealth to go take the matter before the grand jury next week.
Yeah, but what was the matter that I asked him? Was the matter that I think I was asked him to is why the officers hadn't taken any action, if there had been any undue influence exercised in the case or anything like that. Was
well, the
what
court
I was
specifically.
but go ahead.
And I know no more than I saw on the tape from that day. My understanding is the court had indicated that is this the case where he came in and left the courthouse? There is some talk, and everyone generally on the tape agrees that there was an incident where Mr. Riddle was in the courthouse. He was expected to drug test, but then he had left. I
think there was a warrant. I think that actually there was a warrant out for Mr. Riddle, and he came in and asked if there was a warrant there, and he took off out of the courthouse, and they chased him up through the street in public. But I will tell you this: I'd asked on previous occasions whether Mr. Riddle's counsel at the time wanted me to recuse from the case, any of these cases. Every time he comes up, I've asked that because he is actually distantly related to me. And before he got into this series of problems that he's got, his family, obviously his half sister is the district court judge here. And his father is a cousin of mine, which I'd recognize. And Mr. Stockton was informed of those every time he came over. The Commonwealth didn't have any problem. And the defense attorneys didn't have any problem. But now there seems to be a problem that said that I've treated him unethically and have done that sort of thing. So it doesn't bother me at all to recuse from this case and to pass this cup from me. I do take issue as to whether or not I acted unethically. Let me tell you something. When somebody appears in front of the Court of Justice here, and they've been in this Justice Center, there was a warrant for them. They flee and evade, and his sister is the district judge, and it might appear to the public that he was treated differently because of that. I owe it to her and to the public to have the grand jury or someone to take a look at what happened. And that's what I was talking about. I have no prejudgment on him as far as anything he might have done. If there's another case, this case here has nothing to do with that. This case was a burglary case, and it's a completely different case. Has nothing to do with this case. But I will tell you the fact that I have so much knowledge about this case, in my opinion, could call into question if I were Mr. Riddle as to whether I was prejudiced against him or not, although I'm not prejudiced against him in any way. So I'll recuse myself. If you'll draw an order and send it down here, and you can put anything in it you want to, I'll take a look at it and I'll recuse, and we'll get another judge on this case as soon as we can. Okay. Thank you very much.
I'm assuming that for the purpose of going forward and our next court date, we are on for the June 26th date, and that will remain.
No, you can't assume that.
Okay.
Because there's no telling where the judge will come from or when there'll be a judge appointed on it. The way
Understood.
as backed up as everybody is right now. Now that gets me off of all of his cases. Is that correct, Mr. Stockton? This is the only case you have.
It's the only case pending. I've got a question for Mr. Sims. Is he a state prisoner now on the Dyer County case, or is he been held on bond on this case?
Are you finished with the dare, or are you just being held on bond on this, or are you still serving time there?
On
That
that
audio is awful.
I'm a state prisoner on.
Okay, that was my question.
Still finishing that up. Okay.
Okay.
I'll get the order out, Your Honor.
Okay. Thank y'all.
Thank you, Judge.